Hello, and welcome to this makeup lecture for the defenses. So today we'll be discussing two types of defenses. We'll be discussing first justification defenses, and then second we'll be discussing excuse defenses. So as we review, let's harken back to where we started this semester. The semester we started talking about how do we actually analyze a case, right? So if you recall, we spent the first part of the semester asking the question, is there criminal conduct? Right. So whenever we're presented with a case, the first thing we ask, or a fact pattern or a scenario, like you'll have for the final exam, the first thing that we ask is, was there criminal conduct? Remember, criminal conduct is based on actus reus, right? Mens rea if it's required, and other required elements. And that's actually what we're learning now in the course. We've talked about what actus reus is, mens rea, concurrence, attendant circumstances, causation, and harm. Now we're applying that to actual statutes, right? So we've talked about murder and rape, things along those lines. So that's our first question is, was there criminal conduct? If the answer is no, then the person is not guilty. If the answer is yes, there was criminal conduct, we then asked, was the criminal conduct justified? If the answer is yes, then the person is found not guilty. If, however, the answer is no, we have one more step. If the answer is no, the criminal conduct was not justified, then we asked, was the criminal conduct excused? If the answer is yes, the person is not guilty. If the answer is no, the person is guilty. So you'll see that when we analyze a case, there's actually three ways for a person to be found not guilty. But a person is only found guilty once we go through every single step. So we've already done here what's on the screen in blue. We will now move today to what is green, and then we'll move to what is this brownish color. So before we begin talking about talking about specific defenses, let's talk about what defenses are in general. So when we think about defenses, there's really two types, right? There's justification defenses and excuse defenses. So the idea here in both of these cases, the person is admitting to the criminal conduct, right? Saying, I did what that crime is, right? I accept that I did these actions. However, based on the circumstances, my conduct is either justified or excused. So what is justification defenses? Well, a justification defense is when the defendant, the person who's charged with the crime, admits they committed the act, but claims, under the circumstances, their actions were justified. So the example is, I killed her, but it was right to kill her because X, Y, and Z. Right, so you're not saying what you did was wrong. No, instead you're saying, I did it, but under these specific circumstances, what I did was the correct thing to do. Right, it was the right thing to do. Compare that to excuse defenses, in which the defendant admits what they did was wrong. They're saying it's wrong, but under the circumstances, they're not responsible. So here the idea is, yes, I killed her and it was wrong, but I was too insane to control my actions. So justification defenses, you're saying what I did it, yes, but it was the right thing to do. Whereas excuse defenses, you're saying, yes, I did it, and it was the wrong thing to do, but there is some reason that I should not be held responsible. So we're going to look at each of these in turn. One of the first things we're going to look at is justification defenses, and then we will turn to the excuse defenses. But before we get to that, we do understand that we have to be able to prove defenses. So justification and excuse defenses are both what's called affirmative defenses and perfect defenses. So what exactly is an affirmative defense? In an affirmative defense, the defendant must present evidence in support of their claim. So remember, whenever you are charged with a crime, you do not have to prove anything. You do not have to present evidence of anything unless you raise what's called an affirmative defense, unless you raise a justification or an excuse defense. If you raise a justification or excuse defense, then not only does the state have to prove that you committed the crime, then you, as the defendant, have to say, yes, I did, but here's proof of my insanity, or here's proof of self-defense, or whatever it is that you're claiming. So, only when you raise the defense will you have to assert and prove something as a criminal defendant. Now, that being said, not only are these justification excuse defenses what's called affirmative defenses, they are, generally speaking, perfect defenses. And what this means by a perfect defense is if you, as the defendant, are able to show, usually by a preponderance of the evidence, that your conduct was justified, right, or it was excused under a legally recognized justification or excuse, then, if you are successful, that you are able to show this, then you are acquitted, right? You are found not guilty and you are free to go, right? So, yes, you admit that you did it, but as long as you say these affirmative defenses and you're able to prove it, then you can go home. Then the case is done. That being said, insanity, which we'll talk about today as an excuse, is an exception. So insanity is really tricky, and we'll kind of get into it. But generally speaking, if you plead not guilty by reason of insanity, you do not go home. Instead, you are confined to a state psychiatric prison hospital for whatever duration of time the doctors think that you need to be there. So presumably, you are there for life unless you can show, and the doctors believe that you are cured, and then you can get, let out once you have been cured. So again, we'll talk about insanity defenses. They're not raised very frequently, despite what you see on TV. They're incredibly rare that they're raised because both options are bad, right? If you're found guilty, you go to prison. If you get found not guilty by reason of insanity, you go to a prison hospital, right? So if you go to prison, at least you know when you're getting out. With insanity, if you go to a prison hospital, you don't know when you'll get out or if you ever will get out because it's up to the doctors. So again, it's not raised as frequently for this reason. Now, that being said, right, if what happens if you can't present your defense fully, right? So what happens if you can't prove it fully? Well, if you can't prove it fully to be a perfect defense, you might be able to assert what's called an imperfect defense. The idea here is you're not found not guilty, but maybe because of whatever circumstances you state there were and you offered some proof for it, the jury might find you guilty of a lesser offense, or you might get a reduced sentence, right? So the idea here is, let's say that you're claiming self-defense. And, well, it turns out, we'll get into what self-defense is. It turns out that you didn't think there was an immediate threat, right? And you kill a person out of self-defense, but maybe the threat wasn't immediate. But everything was there. The person's been threatening you, the other been stalking you, whatever it is, and you lash out. Well, what might happen instead of getting charged with first-degree murder, they might knock it down to second-degree murder or voluntary manslaughter. Or when it comes to sentencing, instead of getting the maximum, right, the judge might give you the minimum. So again, it's an imperfect defense. It was perfect. If you proved fully your defense, you get to go home. But since it's imperfect, right, since you didn't prove it fully, maybe you might get found guilty of a lesser charge or get a reduced sentence. But again, that's always a big if. The perfect defenses are what you aim for. But, if you don't, for a reason can't prove it, maybe an imperfect defense can at least get you something. Now, that being said, right, whether they're used as an imperfect defense for a less serious crime, or they're used as mitigating circumstances during sentencing, so you get, sentenced to less time. Affirmative defenses, whether they're justification or excuse, are extremely important to know because, again, this is your job not only as future budding lawyers, but for this course for the final. You'll get presented with a scenario, really long fact pattern. They'll have a bunch of different crimes in it. You have to analyze the crimes and then see if there's any excuse defenses that would apply or justification defenses that would apply, and tell me what you believe the outcome would be. So let's jump into the meat of this and start talking about justification defenses. So please remember, that a justification defense is when a person admits that they committed the crime or committed the act, but claims that under the circumstances, their actions were justified. They were the right thing to do. So, we are going to talk about today five major justification defenses, namely self-defense, defense of others, defense of home and property, the choice of evils defense, and consent. So, the first question we have is self-defense. Now, you might see this and say that this kind of looks familiar. Remember when we talked about crime and we talked about, criminal liability, we looked at equations, right? We looked at actus reus and mens rea, concurrence, attendant circumstances, causation. Well, similar to when we look at crimes, here we have defenses. You'll see that defenses are similar in that they have elements. They have their own equation. But remember, the state isn't proving this, the defendant is. So, what are the elements? What are the required things that a defendant has to prove, has to prove in order to assert a perfect self-defense defense? So, they have to show that they are the non-aggressor, their actions was necessary, their actions were proportional, and that they had a reasonable belief that the force was needed. So, let's look at this in turn. First, the defendant has to prove that they are the non-aggressor. So they did not provoke the attack, right? So what this basically is saying is you generally speaking, cannot initiate an attack, get your own attack, talk somebody into hurting you, and then result to using deadly force. Because otherwise you're just baiting a person so that you can kill them. So you cannot, generally speaking, provoke the attack. If you provoke the attack, again, this is all general. If you provoke the attack, then generally speaking, you are not permitted, right, to claim self-defense. That being said, there is one exception, which is called the withdrawal exception or withdrawal exception. So if you do the withdrawal exception, the idea is maybe you start the fight, right, you pick a fight with somebody, and then you make it very clear that you are done with the fight. You are no longer going to attack this person, and you start to like walk away and leave, right? You have withdrawn from that scenario. If that person that you attacked is not done fighting you, and you're walking off and you're done, you've made it very clear that you're disengaging, and then they come up and then pop you in the back of the head or something. Well, now you've withdrawn, even though you were the initial aggressor, you've withdrawn. And so they then become the initial aggressor for the second confrontation. Now, that being said, this is really, really hard because, again, ultimately the success of the defense is up to a jury. And juries don't like it when you start stuff, right? Even if you walk away, juries are still going to look at that and go, yeah, but you started it, right? So, again, it's up to the 12 men and women sitting on the jury whether the defense is perfect or not. But generally speaking, we do not allow it for initial aggressors or people who provoke the attack. And withdrawal exceptions are very rare. They do happen, but it's really within the good graces and the judgment of the jury. So if you can prove that you are the non-aggressor, that you didn't start this, then you have to prove that that it was necessary, that you had the reasonable belief that deadly force, right, was necessary to repel the attack. Right, so basically that you have to show that this was necessary to repel the attack. So we're talking about like murder in this case. If you kill somebody in self-defense, that killing has to be necessary to repel the attack, right? So the idea here is you had to resort to deadly force. If you didn't, you would have been killed or very seriously harmed, right? It's really difficult to say if you're like a 6'5" male, right, and a unarmed 4'2" male with just their fists comes up and slaps you. That's necessary to kill that person, right? Because you're not in any truly physical danger of being seriously hurt or killed. So you have to show that your deadly force was necessary to repel the attack. Not only do you have to show that it's necessary, you also have to show that it was proportional, right? That you have to show that you could not have stopped the attack or repel the imminent deadly attack by using less force. And that's the thing is you always have to use the least amount of force that is reasonable and necessary in the situation. So if it is you shot the person, but you could have stopped the attack by punching them, you have to punch them. You can't just shoot a person, right? You always have to use the least amount of force reasonable in that situation. So not only does it have to be necessary, it has to be proportional. Now, if the person has a gun, pretty much shooting them is always going to be proportional, right? But if they just have their fists, shooting them is probably never going to be proportional. Again, I mean, unless they are like Mike Tyson or Jake Paul or somebody like that, right? Like who could kill you easily by punching you. The average person shooting them is not going to be proportional, right? So you have to meet like force with like force. Just because somebody threatens you, you can't necessarily kill them, right? Unless you are, it's necessary that killing them is necessary and proportional to dispel the attack, right? That they are going to kill you unless you kill them. And then finally, back up to this is related to necessity. The person has to reasonably believe that's necessary to use deadly force, right? So, assuming that you can prove that you were the non-aggressor, that it was necessary to use reasonable force, and you believed it was reasonable belief that it was necessary to use reasonable force, and that you were proportional in the amount of force that you used, then you do have a perfect defense, right? If you can prove all these things, you have a perfect defense, and you will be found not guilty of the crime. So there's some cases for you all to read. We had Ohio versus Baith, United States versus Haynes, and New York versus Gates. Now, you all have briefed these for this class. And since this is going to be a long lecture, we won't discuss it right now. That being said, there are some caveats to self-defense, right? So historically, if you were to raise self-defense, you used to have a duty to retreat, right? So, and there's still some states where this is the case. The idea is you could not put up a fight, you could not use force unless, and this is a big unless, okay, unless you tried to run away first, and that there was no escape, right? You had to historically run away, and if there was no escape and you had to fight, then you could, right? So the idea was you used to have to retreat. Now, what happened is states started to get away from it, right? So to the point is now most states have what's called a stand your ground rule. The stand your ground rule basically says if you are not the initial aggressor, you can use deadly force without retreating from any place you have a right to be, right? So if you're in your home, you don't have to run away. Historically, you used to have to. Or if you're lawfully on the sidewalk outside, you don't have to run away. You can stand your ground and engage in self-defense without having to run away first. So that's where a majority of states are. Now, again, you can say there's some good to this and some bad to this, right? The good is the sense it kind of empowers victims to not have to necessarily live in fear. But the bad is that it encourages vigilante justice. Right. So if we were looking at like Trayvon Martin's killer, um, um, you know, who, basically the man who attacked him basically said that he was able to like he was standing his ground, right? That he said Trayvon Martin essentially attacked him, out on the sidewalk, and that he didn't have to run away, even though Martin wasn't armed or anything like that. That he could use the deadly force, and remember, he got off for that, right? He got off for that. So again, stand your ground rule does kind of it does empower victims, but it does allow vigilantes or maybe even people who don't have the best intentions, right, to use deadly force in situations that don't warrant it, right? Because again, most people would rather not kill somebody, take a human life. Most people would rather run away. Um, so there's a little bit kind of a mix of a good and bad there. That being said, this isn't the universal rule. Several states, um, pretty close to 50-50, several states still require what's called the retreat rule. Under the retreat rule, you must retreat from an attack if you reasonably believe that if you don't, that it would unreasonably put you in serious bodily injury, right? So you have to retreat in several states. So that means is before you can use deadly force, before you can use like really any force, but usually deadly force, you have to try to run away. If there's a way to run away, you gotta do it, right? Before you can use deadly force. Now the exception is if you try to run away, it's gonna put you in more danger, then you don't have to, right? Um, like the idea is let's say that you're cornered on the top of a skyscraper. Do you have to jump off the skyscraper? No, that's insane, right? You could, then push back and use force. But let's say that you're outside in like a park, and somebody approaches you, and it's only one person. They approach you, and you have all this room to run. Do you have to run away first? Yeah, and in these states you do. You have to try and run away. If you can't run away, you're cornered. Then and only then can you use deadly force. Now the question is in these states, right? Um, if the state requires you to run away, what about if you're home? What if about you're in your own house? Well, in these states, most states, not all, but most states recognize the castle exception to the retreat rule, also called the castle doctrine, which is if you're outside, right, of your house or somewhere else, you have to try to run away. If, however, you are in your own home, in most states, you don't have to run away. So the idea is somebody breaks down your front door. In most states, you don't have to try to get out the back window or the back door before you can use deadly force. Now, some states you do have to, right? Some states you do have to. But most states say if somebody breaks into your house, you don't have to run away, because they're in your house. They're kind of accepting the consequences of their actions, and you can use deadly force pretty much straight away. Now, the question then comes up is, what about this retreat rule and people you live with? What if you get attacked by somebody, it's their home too, right? Uh, Most states, but again, not all, say that you don't have to retreat, right? It's called the cohabitation exception. So if you live with somebody, both of you call your house your home, do you have to run away? In most states, you don't. Most states, it's basically the castle exception applies to you. However, some states say no. Some states say if you get attacked by your significant other or a roommate, some states still say that you have to try and run away. But again, this is the vast, vast, vast minority of states. It's only just a couple that still require that. But that obviously and necessarily implicates domestic violence. So when we talk about cases of domestic violence, right, self-defense does apply. So if you are a victim of domestic violence and you are in immediate danger of being killed or seriously injured, in most cases you can, use deadly force against the attacker and you're okay. But the question here is about imminence, about being immediate. So, if you all recall the case that we read for this court class, State versus Stewart, this case involved a really tricky case involving battered woman syndrome. Now, again, this is not a great name because it was what it was historically called. One thing that I want to note is that the more preferred term today is battered partner syndrome or battered spouse syndrome, because the idea is anybody, not just women, can be the victims of domestic violence, right? Whether you're male, female, non-binary, trans, whatever it is, anybody can fall into this role. That being said, legally, a lot of places still call it battered woman syndrome. It's an unfortunate name because it's a misleading name. It's a misnomer. But even if we change the name to something that's more current, battered spouse syndrome, it doesn't make battered spouse syndrome any less tricky. The reason that it's tricky is usually with historically battered women syndrome or battered spouse syndrome, um, people who are the victims of domestic violence, right? they tend to take it until it builds to the point that they can no longer take it, and then they snap and lash out, which was the case in that we read, in the Stewart case, right? And the Stewart case involved this woman, right, who had been horribly, I mean, horribly abused by her husband. I mean, if you read the actual accounts, it's like the worst cases of abuse you ever heard. The woman's children also suffered abuse at the hands of this man, including sexual abuse by her daughters. So this guy was just a horrible, horrible person. To the point that social workers who worked with Stewart urged her to quit her job so that she could stay home and protect her kids from this man. Um, this man was so bad that one time one of the daughters gets hospitalized because of something he'd done to her. Um, because she started having like these extreme emotional problems at the hands of his abuse, and so she gets hospitalized because of it. And when then she has to return home, when she's done being hospitalized, the father makes her sleep in an air-conditioned room and during the middle of the summer with the window nailed shut, wearing flannel. Right, something that was actually very physically dangerous. This guy was just a complete piece of crap. Um, when Stuart tried to protest what was happening, the husband held a shotgun to her head and threatened to kill her. And his behavior towards her after that got so intense that she was hospitalized on several different occasions. Um, and Stuart tried to escape, including a hospitalization. Her husband picked her up from the hospital and threatened to kill her if she ever ran away again. When she returned from the hospital, husband proceeded to rape her repeatedly. And so, I mean, it was just getting worse and worse and worse. And she said that, she truly feared for her life. I mean, this guy was just a complete piece of shit. Well, one night, what happens is she has enough of it. She finds that, he's asleep in bed. So she goes and grabs his gun, shoots him in his sleep, and kills him. And she's ultimately charged with first-degree murder. She tries to raise the battered spouse syndrome, right? Ultimately, the good news is she's acquitted, right? She is found not guilty because I think that even though battered spouse syndrome really can't be used in court, I think the jury heard what he did and had the same reaction I know I did, and I assume you did, of this guy's a real piece of shit. He deserved to die. Um, yeah, so I don't think they actually gave a shit that he died, but it did raise this big problem, right? Because she tried to claim self-defense. Well, the problem is that's not self-defense, right? Because what does self-defense require? The immediate threat of harm, right? You have to be immediately in fear. And in this case, she was not immediately in fear, right? The man was asleep. He could not, in that moment, do anything to her right away within a second. Um, so the question of self-defense becomes this really big issue, and she tries to assert battered spouse syndrome. And even though the conviction stands because it was appealed through this kind of weird channel, or excuse me, the acquittal still stands, the courts basically said that they weren't going to really entertain battered spouse syndrome. That the person that a spouse has to, and this is their kind of conclusion, and most courts still abide by this, the spouse has to be in immediate danger and only uses proportional force. If you read this case, the judges in it were they are three. You could tell who the men were because they're like, oh well, she should have just tried to run away. It's like she did, and that's not how domestic violence works, right? Escaping or just running away, especially if you have kids, is never really an option. It's extremely, extremely dangerous. And domestic violence, usually the abuser controls the finances and everything else, cuts you away from your friends and your family, people who can help you. So it's a very isolating, alone feeling. So if you did escape, where are you going to go? With what money? What about your kids and pets that you leave behind? So again, it makes it really, really difficult for people to escape these situations. That being said, the legal standard still applies, right? We don't, generally speaking, allow battered spouse syndrome into court. But domestic violence victims can assert self-defense, but this does include imminence of danger and the proportionality of force, right? If you're being slapped around, can you shoot the person and kill them? Is that proportional? Depends, right? Probably not. and the threat of violence has to be immediate. You can't kill people in their sleep, um, which again is unfortunate. But keep in mind, it also does come down to a jury to decide, whether this is a perfect defense or imperfect defense. And State versus Stewart, even though legally she did not meet the standard, right, of self-defense, the jury still found her not guilty, partially because I think they heard how horrible this man was and kind of said, well, good riddance. Now, one thing to note is when we talk about self-defense doesn't just apply to defense of yourself. Instead, you can also defend other people. So, assuming that you have all the other conditions of quote unquote self-defense, generally speaking, you can come to the defense of others. So let's say that you see this, person who's, getting the hell beat out of them or, about to be stabbed, and you don't know them. Can you intervene and use deadly force against the person who's attacking them? It depends. It really, really depends. Um, most states say yes. Most states do say yes, that you can come to the defense of somebody else. However, some states take a more strict view. In some states, they still require what's called a special relationship requirement. So in these states, you can only come to the defense of somebody else. You can only use deadly force to defend somebody who's not yourself based on two factors, right? So, depending on the state, some states say that you can only defend members of your immediate family, right? You can only defend members of your immediate family. So if you see your, spouse being hurt, your child being hurt, your mom being hurt, your dad being hurt, you can come to their defense. You can, use deadly force, whatever it is, to help them out. However, in these states, if you see your cousin being hurt, you cannot use deadly force to come to their defense because they are not your immediate family, right? They're not your immediate family. They are a distant family member, which is just rough, right? Because I mean, it doesn't matter how close you are to the person. It's like you could live with your cousin, but the simple fact is they're not your brother or your sister, your child, or your mom or your dad, right? They are not your immediate family, even if you live with them, which is kind of an asinine rule. Other states that require a special relationship say you can come to members of your immediate family, friends, or lovers. Now, one thing that I really don't like about these states, let's say you're walking down the street and you see this grown adult hurting a child to the point that the child might die. You see them just like beating the child relentlessly in a parking lot. You don't know the man and you don't know the child, and that child, like, you really believe that child is in immediate danger. Can you come to that child's defense? Can you like just pop that guy? Well, in states that have a special relationship requirement, the answer is no. You cannot, right? Again, because the defense of others in these states say that you have to have a special relationship. Now, again, this is the minority of states that still require this, but it's a very serious thing. Um, like it does kind of pit legal requirements versus moral requirements. Morally, should you intervene and take that turkey out? Yeah, absolutely. Legally, should you? No, right? Legally, no. Here I would advocate that morality should trump legality. But again, that can you'll go to jail, right? But you'll go to jail hero. Now, the good news is most states have gotten rid of. I mean, there's still quite a few that still have the special relationship requirement, but most states have gotten rid of it. So now in most states you can come to the defense of anyone. So in most states now you can come to the defense of that child or whomever, regardless of your relationship to them. Now, another question comes up is what about if you're trying to defend your house or your property? Can you use deadly force, right, to defend your property? Um, it's hard to say because it really depends on the situation and the scenario and the circumstances, right? So, in these situations, in these scenarios, generally speaking, right, you can use deadly force if you believe an intruder is there to commit a crime of violence. So if somebody's breaking into your home, can you shoot them if you believe that they're going to come in and like murder, rape, something like that? Um, yeah, I mean even before the attack is happening, right? Again, because if the attack is happening, you can use self-defense. We're not talking about the attack on you personally. We're saying somebody's trying to break into your house, and you believe, reasonably believe, that they're there to do something very bad, something violent. Can you use defensive home or property? It kind of just depends, right? Since the attack's not happening, it's not self-defense. You cannot use violence or force if there is time to call the police, right? So, if the person isn't like immediately crawling through that window, that you kind of see him coming up on your property, you should call the police first. If you don't, and you just go start to shoot them, then usually that's a big problem. Now, again, most states now don't require that you retreat, but remember, some states still do. But since it's not self-defense, we're talking the castle doctrine applying. Now, what if the person is not there to commit an act of violence, right? What if a person is there? What if a person is just there to, steal your TV? Can you use deadly force? And the answer is usually no, right? Again, the castle doctrine, it just depends. The states word it differently. But in most places, if the person is not there to commit violence, but they're just there to steal something, can you kill the person? Usually it is no. Um, if it, and I say that with the caveat that it just depends on the state, right? Um, yeah, it truly just depends on the state. But if somebody's walking out with your TV and you pull up to the driveway, can you pop them? Usually no. I mean, at that point, no. You have to call the police, or you can confront them, but you can't initially use deadly force. That being said, most states basically say that if you use deadly force to defend your home or your property, right, it's only when there's entry into the home. Just because you see somebody stepping foot onto your land doesn't mean you can just automatically shoot them, right? So it's not, kind of like we see in the deep south where, you trespass on somebody's land and they pop you. Generally speaking, you can't do that, right? The person has to be actually trying to come into your physical house, not just stepping foot on your property, even to come hurt you. Right? You kind of have to wait till they like actually try to get into the house. That being said, some states have proposed extending the application of defensive home property past the curtilage or to the curtilage, right? So remember, the curtilage is anything surrounding the house, the land surrounding the house, not just the house itself, but all the land surrounding, like a traditional residential lot, right? Some states have proposed extending it to that, and maybe even reducing this requirement that has to be a violent crime that you're afraid of, right? In fact, there was this one case, I want to say it was in Texas. It was very recently, where a little girl was walking down the sidewalk, and I think she was skipping or something like that, and she was bouncing a ball or something. The ball went on the guy's property, and so she goes on to grab the ball, like just roll, like they only rolled like 5 feet on the property. So she goes on to grab the ball, and from the porch he shoots her and kills her. And he tried to say it was defensive home property. She trespassed. Now, even in Texas, that's not going to fly, right? Because again, yes, they extended to curtilage, but did you believe this little girl was here to commit a crime of violence? And the answer is clearly no, right? But if the little girl had a knife in her hand, okay, then yeah, maybe you can take out the toddler. But generally speaking, no, right? Usually, even if we're extending to curtilage, usually we're going to have that crime of violence that we believe the person is going to commit. Um, but if we do extend this curtilage, right, it's really a license to kill. If somebody pulls into your driveway wrongly, as long as you have a reasonable belief that the person is there to commit a crime of violence, you can shoot them, right? So if somebody pulls into your driveway at 2 in the morning, and they're wearing a ski mask, you can just shoot them from your house. Never mind, that's in the middle of winter. Maybe their heat isn't working in their car and they're just turning around. So again, it is problematic, right? It is problematic. So that is self-defense, defense of others, and defense of home property. Let's switch gears a little bit and talk about the choice of evils defense. So the choice of evils defense is yet another justification defense, where again you're saying, yes, I did it, but under the circumstances, it was the correct thing to do. So it kind of does fall into the general defense of necessity, right? Which basically just justifies a choice to commit a crime because it results in a less harm to avoid a greater harm. So what do we mean by this? Basically saying that you're presented with two really bad choices. You can either do the quote unquote crime, and if you don't do the bad crime, something bad, really bad is going to happen, or you do the crime and something kind of bad's going to happen. What should you do, right? The idea is you should always choose the lesser of the harms. So the example will kind of be, it will be a little more quick if I give you some examples. So this case starts out, this defense starts out with a case that you guys did not have in your book. And it's kind of sad because it's a good case. It's called Regina, and Regina just means the Queen of England, versus Stevens, and it's a case from 1884. Basically, what happens in this case is there's this boat out at sea. English citizens. There's a boat out at sea. They're in the middle of the ocean, and the boat goes down. It sinks. So these four guys get onto this life raft, right? There's four guys, and it's kind of one kid. He's a young boy. Who was a cabin boy. They get onto this life raft, right? Old wooden life raft in the middle of the damn ocean, and they are there for weeks, right? As they are there, they don't have food, they don't have water, so all their conditions start to decline. Unfortunately, for the cabin boy's condition is declining at a much greater rate than everybody else's, to the point that he's very lethargic. He looks very, really, really bad. Like there's no question that he's going to die really soon, um, probably within a few hours. He's still kind of conscious and still kind of lucid, and the other guys are talking, and they realize that if they don't do something drastic, all of them are going to die. And so they come to the conclusion that one of them must sacrifice their life so that people can eat them, right? So that they don't die. Eat them and like drink their blood, hopefully, sustaining them for a while until they can get rescued. And so the men are talking, and all of them have families, right? All of them have like wives and kids to get back to, except the cabin boy. The cabin boy does not have a family, right? And is very clearly in the worst condition, is clearly going to die the soonest. So the men make the really difficult decision. They kill the cabin boy. They take a knife and they feel really bad about it, like legitimately, like this is a person they liked. They kill him in the life raft, and then they proceed to eat his organs and drink his blood. And a day later, after they do this, they're rescued. Right. So they're rescued by a ship passing. They get back to England, right? They tell the account of what happened, and what happened. Obviously, the remains of the cabin boy are in the boat when they're found, and ultimately, right, they get charged with murder. And at the time in England, they didn't recognize this defense, but they presented this defense, right, saying, "Look, what were our options? Our options were all four of us die if we didn't eat this kid, or we kill him and one person dies, but three of us lives. Which is the bigger harm? We chose the lesser harm. We chose one person dying over four." Now, in England, they didn't really recognize it, and ultimately the Queen kind of pardons them. It's a whole big thing. But it does set the stage, right, for this idea of choice of evils. The idea of choice of evils is you really do are weighing two really bad options. Right? Option A is I don't commit a crime and something horrible happens. Or option B, I do the crime and something less bad happens. What do we want you to do legally? Legally, we want you to do the less bad, like the less bad result, right? Even if it means committing a crime. So here's some examples, right? Let's say that you're, wandering through the wilderness. You go out, you decide to go on a hike. You're out there, and it's right. This is this time of year. It's kind of warm today, so you're out there in shorts and a t-shirt, and you're on this hike. And once you know it, unbeknownst to you, a freak snowstorm comes up, and like the blizzard, and you were out in the middle of the woods trying to hike, and then boom, you get hit with like feet and feet of snow, and it blocks your path. Like you're gonna freeze to death out there. So as you're trying to like make it back to your car, like going slower and slower, slower, thinking you're going to die, you see this kind of cabin over, kind of adjacent to the woods, and you're like, okay, maybe somebody there can help me. I'm going to die. So you beat on the door, and nobody's home, and you're about to freeze to death, right? You have an option: freeze to death, or what? Break into the house, right? Like kick down the door, break a window, climb inside, whatever it is, to try and live. No, unfortunately, breaking into a house is breaking and entering, right? It's a crime. It's a felony in a lot of places. What do we want you to do? We want you to break into the house, right? Legally, we're saying break into the house. Because what's the harms? Harm A, a human dies. Harm B, you have to replace a window or a door, right? Um, One is significantly worse than the other. So if this is a situation you presented it, you can get charged with breaking and entering, but then you can assert the choice of evils defense saying, hey, I chose the lesser of the two bad things. Similarly, dispensing drugs without a prescription, right? Let's say that you are not a doctor and you're in an emergency situation. You see, maybe you are a heart patient, and for all heart patients, especially they have certain heart conditions, carry nitroglycerin around with them. It's just a tablet that they can take that helps stop heart attacks, right? And let's say they're outside and they see this guy collapse on the ground, and it looks like truly he's having a heart attack. And so they go into their own bottle and give the guy a nitroglycerin, right, to help stop his heart attack. Well, what's the problem here? They just prescribed a drug without, being a doctor. Okay. Well, what's our choice of evils? Choice of evils, you can die from a heart attack. So a dead person from a heart attack versus you gave somebody a pill that you shouldn't have, right? We'd rather you give them the pill that you shouldn't have as opposed to them dying. Similarly, speeding, right? We've all seen this. Is you're speeding to get to the hospital, you get pulled over, the person's in labor or they're dying. Um, are you going to get a ticket? I mean, you might. The cop's a jerk. But can you fight it by saying choice of evils? Yeah, like if I wasn't speeding, this guy would have died. We'd rather you speed than somebody die. We'd rather you speed than a baby's not born in the hospital. Right. So that's kind of our choice of evils, right? Is sometimes we want you to commit a crime. If not committing a crime is going to cause a bigger harm. So then how do we actually test for choice of evils, right? How do we test for choice of evils? So we test for choice of evils by having to take 3 steps. First, we identify the evils, right? What is the harm from committing the crime versus what is the harm for not committing the crime, right? Then we rank the evils, right? So what's the more severe of these two harms, right? And then based on your ranking, on the belief that the evil greater is imminent, the defendant has to choose the lesser of the evils, right? So, example, breaking and entering. Okay, breaking and entering. What's the evils? You're invading privacy. You're invading somebody's property. That's the evil. What's the other evil? Human death. Rank them. Which is more severe? Human death or breaking into somebody's property, invading privacy? Human death. And as long as you choose the lesser of the two, in this case, breaking and entering, right? Then it's a perfect defense. If, however, you choose the greater, right, then that becomes a problem. So the last justification offense we'll talk about is called consent, right? So consent is this idea that as grown adults, we or you are capable of consenting to certain crimes against you, right? You are capable of consenting to certain crimes against you. Um, as long as you are a competent adult, right? So you're an adult and that you're mentally all there, that you don't have some kind of like intellectual deficiency, that you voluntarily consent to the crime against yourself, and that you know you're consenting to it, generally speaking, we are going to allow it, right? We are going to allow it. Think about, right? Um, I mean, think about, I guess, how many crimes that actually exist that if the people didn't consent to them would be a problem, right? Would be a problem. Now, that being said, most states do not allow you to consent to your own murder or your own battery. And I should put a big asterisk by battery, right? So, can you consent to your own murder? No, you cannot. In no state, under no reason, really, can you consent to your own homicide. You simply can't, right? So you can't tell your friend, man, I want to end my life. I'm suffering medically or whatever it is. I want you to do it to me. I'm too scared. I want you to do it to me. That person can't then say, well, he consented. Nope, sorry, you can't consent to your own murder. That being said, most states say you can't consent to your own battery, but there's a lot of exceptions, right? So, for example, our exceptions are if the injury is not serious, right? We all have friends, right? That we play fight, or like I know with my friends, we're old, you still like hit each other in the shoulders or whatever, like it's playfully, or playfully pushing people or whatever it is, right? That is technically a battery, but can the person consent to it? Sure, right? Yeah. If it's part of your all's relationship and you guys all do it and it's customary, you guys know what you're doing, then yeah, you can consent to that. Sporting events, right? I love football, but what is football except a bunch of people committing a lot of crimes against each other? And think about it. You're out there playing football. Your whole job is to like beat the living hell out of somebody, by tackling them and hitting them and stuff like that. Well, if you do that outside of a football game, that's a lot of felonies. But then why don't, people in the NFL, why don't NFL players all get arrested when they walk off the field? Well, they don't get arrested, generally speaking, because right? They're consenting adults, right? They voluntarily consented to crimes against them. They know what they're consenting to, and they start to play it. Now, what's interesting is you guys had the case of the State versus Shelley or Washington versus Shelley, which did involve this idea. It's a basketball game, but question is how far does consent go? How far does consent go? So let's say that the whistle is blown. Let's say it's a football game. The whistle is blown, and somebody does a late hit, right? Will they get a penalty? Is that a crime? Generally speaking, courts are going to say, similar to Shelley, no, it's not a crime, right? It's a penalty. It's a foul. You're going to lose yardage or whatever it is, but it's not a crime because again, part of sports, there's going to be late hits. There's going to be penalties. You're kind of consenting to that. But let's say that the whistle is blown and 2 minutes have gone by and like commercial break, whatever it is, and one of the players walks from his side of the side of the field to the other side of the field and just jumps on another player and starts punching him. At that point, does a crime occur? Yes, right? Because at that point, it's not just a part of normal gameplay, right? It's not just a normal penalty. You've done something well outside the scope of the actual football game itself. At that point, the person didn't consent because they consented to being hurt on the field. They consented to just some kind of brief penalties. They did not consent to after a couple of minutes you walking to their side and just starting to punch them because that's not a part of football, right? So again, even sporting events, there are limitations. Just speaking, fouls are going to be okay, but if it goes well beyond that, then we have a problem. Similarly, is if the injury benefits you, you can consent to it. Think about if you've ever had surgery before. What is surgery? It's a person cutting you open, right? Why aren't surgeons arrested after every single time they cut you open? That's a battery, right? It's a serious battery. Why aren't they arrested? Because you've consented to it, right? And because it benefits you, right? It benefits you. Now, that being said, that's why informed consent, if you ever have surgery, you have to sign all those informed consent forms. It's so important because there's a limitation, right? There's a big, big limitation. Let's say that you go in to have your appendix removed, right? And let's say that the doctor accidentally removes your gallbladder instead. Can you sue them? Yes. Is it going to be a crime? Well, no, because there's some intentionality problems there, right? If they made a mistake, they make a mistake. But let's say that you go in for an appendix surgery and the doctor removes your appendix. But while they're in there, they're saying, you know what? I think this person would like, a breast enhancement. So while you're under, you remove your appendix, they remove your appendix, and then they give you breast implants. Um, is that a crime? Yeah, absolutely. That's not a mistake, right? And you didn't consent to it. You consented to the thing that was going to help you that you as a grown adult, you agreed to. You did not consent to the other thing, right? You did not consent to the enhancement surgery. So because of that, the doctor, yeah, can you sue them? Yes, but can they be, charged with a crime? Absolutely, because you consented to your battery, but again, you limited the scope to my appendix. If you go above and beyond that, well, at that point, then we're talking a crime. Similarly, right, if the injury is a part of sexual conduct, now again, I have to stress this, has to be an adult, has to be a competent adult, and they have to voluntarily consent to it. But we don't criminalize people doing freaky things. We don't, right? As long as they're between adults, they're all competent and they're all consent. Generally speaking, we don't care. So otherwise, people who are into like BDSM, that kind of thing, those are major, major crimes that they could be charged with. But in this case, we don't charge them. We simply don't. The reason we don't is because, hey, as long as you're an adult, you're competent, and you've agreed to it, you can be choked, strangled, slapped, pierced, punched, whatever it is. You can agree to it, right? You can agree to it. What we're seeing actually a rise of when it comes to this is people who engage in what's called, was it CNC, consensual non-consent. So some people, I guess, in the BDSM community have like a relationship agreement that, they will, the parties don't need consent from the other party to initiate sexual activity or even force the other person to do it, but they've agreed to it, right? Well in advance. Um, well, what is that? That's straight up rape, right? The person says no, that's rape. But you get charged with it, you raise the defense of consent, saying that, we agreed to this, it's a part of our play, whatever it is. Part of the reason I understand in the BDSM community, like they're big on written contracts. As a lawyer, I'd love to have, like, if you're going to do something like that, write it down first. Make sure both parties sign it, so at least you have some documentation and proof that this is truly voluntary and voluntary part of sex and not a part of an actual rape that's occurring. Um, but you can see where like people can consent to stuff that would outside of consent be a massive major crime. So that being said, that's our excuse defenses. Now, excuse me, that's our justification defenses. Now we are going to move into excuses. So similar to what we saw with justifications, with excuse defenses, we still gotta go through our analysis. So we ask, is there criminal conduct? Was it justified, which is what we just did? And if the answer is no, then we move into excuse. Right, then we move into excuse. So, for excuse defenses, right, the defendant admits what they did was wrong. Remember, justification, you're saying what you did was right under the circumstances. For excuse defenses, you're saying what I did was wrong, but under the circumstances, I am not responsible for my actions. And we'll talk about these. We'll talk about these. Specifically, we'll talk about insanity, diminished capacity, AIDS, age, duress, intoxication, and entrapment. One thing we will not talk about is syndromes. I know your book discusses it a little bit, including PMS and PTSD, because generally speaking, these are not recognized by law. Sorry. So let's talk about our overview of excuse defenses. We're going to jump into each one of these in turn, beginning with insanity. So we're talking about insanity, right? This idea of competency is not a defense, but in order to be deemed competent to stand trial, you have to be able to understand the legal proceedings and consult with a lawyer in aiding your defense. So you all have probably heard in the news, right, somebody that has been deemed incompetent or not competent to stand trial. What this means is they're not insane, right? They're not getting found not guilty. They're not getting let off the hook. Instead, their trial is being put on hold indefinitely. So we're talking about putting on a hold. What we're what we're actually saying is that this person does not have the capacity to understand the legal proceedings or consult with a lawyer. So what happens is they'll be ordered to undergo psychiatric treatment, whether that's hospitalization or medication or combination of both, until such point that they are capable to understand that they're competent to understand legal proceedings and consult with a lawyer. At which point, then they can stand trial. So again, this isn't insanity, but this is about competency. Now, I know some of you probably think about statute of limitations, right? If you are charged with a crime, but you're deemed incompetent to stand trial, the statute of limitations is paused. It's told, right? Until such time that you are deemed competent to actually stand trial. So that's competency. That's drastically different than insanity. Because competency has nothing to do with not guilty or being at the insane at the time the offense was committed. Instead, what we're concerned about is insanity. So, with insanity, every state defines insanity a little bit differently. And every state defines it a little bit differently. So, several states use what's called the right-wrong test or the McNaughton rule. And this was the kind of the case very early on, right? The McNaughton rule basically said that if you were to try to prove that you were insane at the time that the offense was committed, right, you had to show that you suffered a defective reason caused by a disease of the mind, right? So that you had some underlying psychological issue that impacted your ability to make reasonable, rational decisions. And at the time of the act, that you did not know the nature or quality of your act or that your act was wrong. So the idea here would be something like severe schizophrenia, right? Which is a disease of the mind that does impair reason. But just having schizophrenia alone is not enough to get you insanity. What you have to prove as the defendant is not only did you have schizophrenia, but at the time that you did the act, the schizophrenia was so bad that you did not know what you were doing or that what you were doing was wrong, right? So we're talking about severe, like auditory and visual hallucinations that made you believe, maybe a psychotic break, right? That you weren't actually stabbing somebody. Instead, you believed that at the time you were on Mars and you were killing these alien invaders, right? Which wouldn't necessarily be wrong. That is what we're talking about. So it's not just somebody being diagnosed with a medical condition. Instead, you have to have for the McNaughton rule, you have to have some kind of underlying medical condition and that it was so severe and pervasive that at the time you did not know what you were doing or that what you were doing was wrong. Compare that to the irresistible impulse test. With the irresistible impulse test, basically, this is some states that ask is twofold. One, was the mental disease caused by the defendant to lose the power to choose between right and wrong, even though they knew it was wrong, and to avoid the alleged act? The disease destroyed their free will, and right, the mental disease was the sole cause of the act. So here they knew that what they were doing was wrong, right? So again, some states use this with a combination of McNaughton. It's like a little bit different spin on it. So they knew what they were doing was wrong, but they had some kind of mental disease or defect which made it impossible for them to do the right thing. And that it was the mental disease that caused them to do the act. So sometimes you see this come up in cases. I know there's a really famous case involving kleptomania that a person had. Kleptomania is when you have to steal. There's just something in your brain, your mind that makes you have to steal. Even if you have the money to pay for the thing, you have to steal. In fact, there was a celebrity a while back who had kleptomania. She was this multimillionaire who would go and just shoplift constantly. And she would always have, like 10, 20 grand on her in cash. and she would just shoplift and get caught. She had kleptomania, and ultimately she did basically plead that she was insane, right? That at the time she had this irresistible impulse that um, even though she had the money, she just stole because she had to. She knew it was wrong, but it was just something in her brain that made her do it. That's irresistible impulse, right? That you, and again, usually it has to be documented before you do the crime, right? Sometimes you can do it after, but usually it has to be documented before. Compare that, right, to yet another insanity test, which is the Durham rule, right? The Durham rule is pretty straightforward. Basically, it just asks, was the act the product of a mental disease or defect, right? Now, the Durham rule is not super favored, and most places don't have it. I don't actually think any states now currently have the Durham rule. But the Durham rule basically asks is, did you do the crime because of a mental disease or defect? But that's a really broad interpretation, right? Um, you could argue like I did this because I was anxious, or I did this because I was depressed. It's a really broad interpretation that like a lot of states don't really like because it's so far out of the realm. Instead, right, we still see quite a bit of the not rule. Irresistible impulse test kind of supplements insanity, but where most states lie, and what we'll talk about in terms of this course, is the substantial capacity test. This is what the model penal code uses. So for here, it's pretty similar to McNaughton. And what you're saying that the crime is one, result of a mental disease or defect, and two, the defendant lacked the substantial capacity either to A, appreciate the criminality or wrongfulness of their conduct, or conform their conduct to the requirements of the law. So again, the crime had to be as a result of a mental disease or defect, but just having a mental disease or defect does not negate, your mens rea. But it also requires that you lack the substantial capacity to appreciate how what you did was wrong or to act in a lawful manner. So again, these are the steps, these are the things you would have to prove. For instance, if you guys have a hypothetical where a person seems like they're acting insane, you have to say, okay, first, does this person have a mental disease or defect? Second, do they have the substantial capacity to appreciate their criminality or to conform their actions to the requirements of the law? So if you read this, right, somebody has to be really, really, really mentally impaired. Um, this isn't just having schizophrenia, right? Because you still have to meet the rest of this. The schizophrenia that's so untreated or so severe that the person can't appreciate what they're doing. Or Alzheimer's is a big one. Um, that's one we see a lot, and it actually does happen sometimes in nursing facilities, where an Alzheimer's patient who has Alzheimer's, so mental disease or defect, will attack another resident, right? Um, but they are just so out of it that they can't conform their actions to civility, or they can't appreciate what they're doing is wrong, right? They are just so out of it. Um, that's the degree we're talking about. You can't just say, "Oh, I was really depressed or I was anxious," right? It has to be much more than that and much, much more severe. Because remember, if you get to plead this as a perfect defense, you don't go home. You go to an institution. Now, if you're already in a nursing home, you're old and you have dementia, you're just going to go to a more secure nursing home. They're not going to put you in a prison hospital. But if you're just a normal person, you're going to a prison hospital, right? Indefinitely until you get better, which with some diseases is never, right? A lot of diseases, even with treatment, are progressive. They will get worse and worse and worse and worse and worse. They are progressive. Um, so it's not great. It's definitely not great. But some people do get out. For example, fairly recently, John Hinckley got out of uh, a federal prison hospital. So John Hinckley, I don't know if you all know that name, he tried to assassinate Ronald Reagan. Right? He did actually. He shot Ronald Reagan. He also shot his press secretary. Press secretary ended up in a wheelchair for the rest of his life. And Ronald Reagan almost died. Like he had to go to surgery, and he was in surgery for quite a long time, and he almost died. John Hinckley truly believed that he. I mean, he was legitimately insane. He shot Ronald Reagan because he believed that Jodie Foster, that actress from Silence of the Lambs, he believed Jodie Foster really wanted him to, and that if he shot Ronald Reagan, that he and Jodie Foster would be together forever. Again, this person had delusions of grandeur, schizophrenia, paranoia, to the point that he had convinced himself that this person, his paranoia was so bad that he loved this person, that she loved him, that he couldn't conform his actions. So he spent like the last, I don't know, it's almost like 20 or 30 years in a state psychiatric or prison hospital. And he was finally deemed competent or deemed sane enough to be released. Now, I mean, he's an old man now, right? Um, so again, it's not like you just go in there if you can be cured that they get you out in 6 months. I mean, you're in there for decades, if not for life. And again, it's super rare. It's part of the reason that we never plead insanity as lawyers unless you're insane. It's one thing that I think lawyers get a bad rap in the community is people like, oh, they just plead insanity and people get off. It's like, no. Lawyers very, 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 very rarely plead insanity because they know the consequences, right? And you're definitely not pleading insanity for something other than like murder or a life sentence. Could you plead insanity for, I don't know, stealing a car? Sure, you could. But you go car theft, you're looking at, like 2 to 5 years, somewhere in there in prison. But if you go for insanity, you could be looking at a life sentence. So it's very rarely pled. That's like less than like 1% of 1% of cases. It's very, very rare that it's pled because the conditions are so severe. And the test is so high. I mean, it's not just did you have a mental problem, it's how bad was that mental problem? How severe was it? How pervasive was it? Was it documented? Were you taking meds? Like, there's a lot that goes into it to see if somebody is truly insane. Now, that being said, what if they can't meet the full test of insanity? Well, if you can't say that they're fully insane, you might be able to insert kind of an imperfect defense of diminished capacity. So diminished capacity, right, is a failure-proof defense. It's not an affirmative defense in which the defendant attempts to prove that he is incapable of the requisite intent, right? So let's say that statute requires that you do something purposefully. But what you're trying to say is, look, I had this mental problem that I can't do things purposefully. I can't do something premeditated. I can't plan something because I have whatever this disease is, right? So the idea is here you're not saying that you're insane necessarily, but what you are saying is you are incapable, right, of the requisite intent. So the statute requires purposely. You're saying I can't do something purposely. I don't have the mental capacity to be able to do that. Right. So this could be something like an intellectual disability, like you have such a low IQ that you simply just cannot, do something legally purposely. Or it could be, the term is mental disease or defect that prevents it. Now, that being said, right, that doesn't preclude lesser included charges. So first degree is usually purposefully. Second degree is knowingly. Third degree, or, like third degree like involuntary manslaughter is recklessly. Well, recklessly, I mean, you might be able to perform something purposefully, but you could, put somebody at risk knowing what you're doing. It's not your goal, but maybe you are. So you could still be charged or convicted of something lesser, right, than the top crime. But compare that to diminished responsibility. Whereas diminished capacity is failure proof of you get to go home because you say that, hey, it's impossible for the prosecution to prove that I met the requisite mental intent because I have this medical condition or I have this intellectual disability. Compare that to diminished responsibility, in which the defendant is trying to prove, right, that they're less responsible, they're less culpable for their crime. And here we're talking about sentencing. Diminished capacity, you get to go home. Diminished responsibility is insanity. You try to prove it, but maybe you don't meet the full requirements. But, right, you might be seeking a lesser punishment, or getting punished on a lesser included charge. So the idea here is, yeah, you're not fully insane to the point that it negated everything you did, that you weren't responsible, but maybe you were so severely impaired that it's not fair to punish you the same degree as somebody else, right? So you can always use diminished responsibility as a way that, if it's an imperfect defense, of insanity to say that, yeah, I mean, I was technically sane, but I was so impaired that, yes, I'm technically responsible for my actions, but it's not fair to punish me to the same degree as somebody who didn't have these impairments. That is very similar to a certain degree, to a certain extent, to the defense of age. Now, age is really interesting, right? Because under common law, there are age ranges in which somebody can be held responsible for committing a crime. So in the United States, a child under the age of 7 cannot commit a crime. Let me say that again. If you are under the age of 7, it is impossible, legally impossible, for you to commit a crime. Right? So if you are 6 and you grab a gun and you shoot somebody, you will not be in trouble. I mean, your parents might be, right, for leaving a gun out or whatever it is, but you as a child aren't. Because, like, if you're under the age of 7, you have no criminal capacity. The idea is children under the age of 7 don't truly know the difference between right and wrong, right? Um, Especially when it comes to big life decisions. Right. I'm thinking about like a 6-year-old or a toddler, like a 5-year-old, you take them to a store, they grab a piece of candy when you're not looking. Right. Is it truly fair to charge that child with shoplifting? Probably not, right? Because they don't really understand what's going on. They just see candy and go, I want, right? We're not going to charge them. That's not fair. They don't have the capacity to commit a crime. But once they hit 7, right? They presume to have no criminal capacity, but it can be rebutted. So between ages 7 and 14, we presume that you don't have the capacity to commit a crime. However, that presumption can be rebutted. So the idea is we can prove that, well, you're actually 13 at the time you did this. You do know the difference between right and wrong. You do well in school, right? You've learned basic law in school, or you've taken social studies. Um, then yeah, we can charge you, right? But between 7 and 14, it's iffy. It's iffy. Usually, the younger you are, the less likely it is you're going to be charged, and the older you are, between 7 and 14, the more likely it is you're going to be charged. That being said, we also look at the severity of what you did, right? Um, should an 8-year-old know that murder is wrong? Yes, absolutely, right? That killing somebody is wrong. So if you're 8, are we going to charge you with murder? Yeah, absolutely, right? If you're 14 or 13, are we going to charge you with murder? Yeah, absolutely, right? The more severe the crime, the more likely it is you're going to be charged with it. Again, this will be held by, presumably, dealt with by the juvenile courts, right? So they're a little bit different. But generally speaking, you are going to be held responsible for your actions, especially the more severe it is. Think about something that maybe isn't as severe, but you know, that a kid who understands that murder is wrong might not be able to fully understand that this one thing is wrong. So, for example, think of something like jaywalking, right? I mean, it's just a ticket, but a child can understand that murder is wrong. That killing a human being is wrong at age 8, 7, 8, easily. But how about crossing the street at something other than a crosswalk? Can they truly understand that? Probably not, right? Because instinctively they know that the killing is wrong, but crossing a street at certain times probably not going to be instinctively wrong. So again, age, the more severe it is, the more likely it is we're going to say that you're responsible, as opposed to the less severe stuff. And again, the older you are, the more likely that goes up. That being said, when you're 14, you have the same criminal capacity as an adult. Right? Now, that doesn't mean you'll be charged as an adult. Usually that's up to the charging body. Um, so most of these crimes, even at 14, over 14, are going to be held by the juvenile courts. So they're sealed and there's protections that don't apply to adults. But once you hit 14, you have the same criminal capacity as an adult. And at that point, right, they could theoretically charge you as an adult. It's up to the state statutes, the charging body, the judges, etc. But that's our line of demarcation. That is our line of demarcation. So one of the things that you had in your book was State of Washington versus KRL. Remember, with abbreviations, we have initials. That just means the person is a minor, right? So in KRL, basically what happens is KRL enters the home of a neighbor, Mrs. Jet without permission. While inside, he took a knife from the kitchen and cut a screen. He was later found outside the house with a knife. Now, the state charged him with residential burglary, right? Um, Essentially, that he came into the house and he did some damage, um, in which he required that he knowingly entered the home with the intent of committing the crime. Now, under Washington law, children between the ages of 8 and 12 are presumed incapable of committing a crime unless the state provides clear and convincing evidence the child understood the wrongfulness of their actions. So the question here was, um, you know, does he have this intent? So ultimately, he is convicted at trial, right? They try to show that he had intent, and he appeals and he says, "Look, I didn't have this intent because I was so young. I was a minor. I did not understand the wrongfulness of my actions." And the court ruled here that the state had failed to prove that this child, um, even though that they were 12, had this capacity, right, to knowingly enter a building with a purpose of committing a crime therein. Specifically, all the state introduced was evidence that this minor had been disciplined in the past for misbehavior. Um, that's all they presented. Right? It was like, yeah, he had received discipline by his parents and by school for acting up. And the problem was like, what? That's it? Like that doesn't show this kid knew what they were doing, they're doing right and wrong. Especially when you look at the developmental considerations, that like children often act out of curiosity or impulse without full understanding of what they're doing. And since you didn't provide any evidence that this child knew what they were doing was wrong, or should be treated like an adult in this regard, or at least be held responsible criminally for their actions, that they can't be. And so ultimately the case gets dismissed. Next one we'll talk about is duress. So duress is it's kind of related to necessity, slightly, right? So duress or necessity, necessity or choice of evils. This idea is you're choosing the lesser of the two evils. Under duress, right, is you are forced to commit the crime, not necessarily by society or like some like weather event or something like that. Instead, you're forced usually by another person to commit the crime, right? So generally speaking, let's say that somebody breaks in and puts a gun to your head and says you have to go commit these crimes. Well, in that case, you could plead duress that if you didn't do it, right, that somebody was forcing you, that something really bad was going to happen. So, what are required elements for duress? Well, we have to look at what is the nature of the threat, right? Um, what are they threatening to do if you don't commit this crime? They might say, "Hey, I want you to go, rob the gas station, and if you don't, I'm going to publish your nudes online." It's like, well, okay, that's not great, right? That's not great, but that's also not super severe. Nobody's going to get hurt from this. Whereas it's different than you need to go rob this gas station or else I'm going to kill your spouse. Okay, now that's a whole different bag of worms, right? So we look at the nature of the threat. What are you being threatened with if you don't do this crime? We also look at the immediacy of the threat, right? Is this something they're threatening to do 5 years from now? If you don't go rob this bank and in 5 years, I'm going to burn down your house. It's like, okay, sorry. I got 5 years to call the cops and get this investigated. That's not going to fly. The level of belief regarding the threat. Do you actually believe this person will do it? Or do you know they're full of crap? Like, if they're full of crap and you know they're full of crap, then you're not under duress. And we also ask, what crime did you commit out of this duress? Because usually it does not apply to murder, right? So the idea is if somebody puts a gun to your head and says, kill your wife, you can't do it. You got to take the bullet, right? Um, you can't kill somebody usually with a crime of duress, right? Now, it gets tricky, right? It doesn't feel good. Just think about it, like somebody has, like, say, a gun to your kid's head and says, if you don't go kill your neighbor, your child dies. Ooh, that's a hard one, right? If we have a true reading of duress, you should just let the child die. But there's no parent out there who would. And I don't think there's a jury out there who wouldn't give them the duress as a way out. But technically, they're not supposed to. That being said, duress isn't super common. It does occur. We do see it with like sextortion cases are fairly common, especially unfortunately with younger kids, like kids, teens, and college age students. Like if you don't go do X, Y, and Z, that's illegal. That's a crime. Then I'm going to leak your nudes or something like that. That's a fairly common one, unfortunately. It's very rare that somebody puts a gun to somebody's head or to their spouse's head, like you see on TV, and makes them do something. That's super super rare. Very very rarely happens. Usually it's some kind of like financial threat or sextortion case or something along those lines. That being said, one of the craziest stories that it's from here in Pennsylvania, that if the person hadn't died, would have been easily considered a crime of duress. Happened in up here. It happened in Pennsylvania. So basically, what happened in Pennsylvania. I don't know if you guys have Netflix. I think that the show's still in there. It's a documentary series called I think it's called like Mastermind or Evil Genius or something like that. Um, Basically, what happens is this pizza delivery guy gets called out to like this weird, like kind of like far out radio tower, kind of out in the middle of nowhere to deliver a pizza. He delivers it. He gets out of his car to go knock on the door to deliver the pizza. And these people jump out. They grab him, wrestle him to the ground. They put a collar around his neck. The collar has a bomb built into it, right? The bomb is built into the collar on his neck, and then he's given a note, and he's also given like a cane with a gun in it. It's like this. They give him these different supplies, and basically it says that there's a bomb around his neck, and the time is ticking, and that he has to go rob this bank, and then like basically do this weird little scavenger hunt afterwards to get the key to the bomb in his neck to release it so he doesn't die. Um, and so he does what he's told. Like he goes to the bank, he see him walk in, has this bomb strapped around his neck. He robs the bank, and then as he's leaving the bank, he gets about 10 yards down the road. Please stop him, right? And they pull him out of the car. He says, I have this bomb around my neck. Please help me. Please help me. Please help me. And the police are real skeptical of him, which is unfortunate. They don't treat him as a victim. They treat him as somebody who's a really bad person. And news crews catch wind of this, and there's a standoff. They have this guy in the middle of a parking lot. Everybody's backed up because there's a bomb around his neck. And news crews are filming, and the bomb squad's on its way, but unfortunately, they shut down all the roads to this area. The bomb squad can't get through the traffic, and on national television, the bomb goes off around this guy's neck, and he dies. And they actually show it in the documentary. It's wild. It's a hard watch. Like, I mean, if you're sensitive to that kind of stuff, don't watch it. If you're not, if you take my like criminal investigation course, yeah, it's nothing that'll bother you. Um, but it's intense, right? And theoretically, if this man had not died, right, and was just arrested, they got the bomb off, they tried to charge him with bank robbery. He could then provide duress as the defense, right? He could have, because what's the nature of the threat? If he does not go rob the bank, his head blows off and dies. How immediate is it? Pretty immediate because there's a bomb around his neck and the timer is set for like 20 minutes. What's the level of belief regarding the threat? Random people jump the guy and put a bomb around his neck. There's a literal bomb around his neck. It's a pretty, really good belief. And what's the crime he's doing? Is it killing somebody? No, it's bank robbery, right? So he would have, if he had survived, would have had a perfect duress defense, right? Those are the ones that are pretty easy. Where things get a little more difficult, as I was mentioned before, is like sextortion, those kind of things. Those get a little bit more tricky because the question is, what's truly the nature of the threat? Is somebody getting hurt, or is it just reputational damage? Um, you know, obviously the worse the threat, the more likely the duress will apply. Then we have intoxication. Again, intoxication is what you're saying is what I was doing was wrong, but under the circumstances, right, I should not be held responsible for my actions. Understand with intoxication, there are two types of intoxication. There is involuntary intoxication and voluntary intoxication. Generally speaking, the defense of intoxication only applies to involuntary intoxication. So it's not like you see on TV where people will say, "Oh, I was drunk. I should be held responsible." Sorry, if you went out drinking and you intentionally got drunk, you are responsible for your actions. If, however, you were forced to drink or forced to take drugs, or that you did not know that you were taking drugs or intoxicants, then you are not responsible for your actions. So, one thing we see this a lot happens at bars, right? So let's say that you go into you're at a party, you're at a bar, whatever. You're drinking responsibly. You have one drink. Unbeknownst to you, somebody slipped something in it, right? Obviously, the big date rape drug is Rohypnol or roofies. Somebody puts Rohypnol in your drink. Now, depending on the dosage, it doesn't necessarily make you always black out. A lot of times, it just kind of makes you lose control. Doesn't make you like physically black out, but like mentally, it kind of causes the blackout. But you're still, functioning and doing stuff and whatever. Um, in that case, if somebody slips something into your drink and you did not know it, let's say, and now you're kind of out of it because somebody drugged you, and then you get into your car and drive, you kill somebody, right? Well, at that point, you can claim involuntary intoxication, right? Because you only had one drink. One drink is not going to get you drunk. I mean, you have to prove it, which sucks. That's the hard thing to do, right? You have to prove it. Um, but if they find roofies in your system, you'd be like, yeah, I didn't do that. Somebody roofied me, so it's not my fault what happened, right? Or somebody forces you to get drunk or something like that, right? Like you put a gun to your head and say, drink all of this. Um, that is only when involuntary intoxication applies. Um, that being said, even then it's really hard, right? Like I was involuntarily drunk, but you were at a bar, so like it's hard. So usually you have to prove against, and it's hard to prove, right? How do you prove that somebody roofied you? Hopefully you get blood tests that show there was roofies in your system, or hopefully there's some witnesses that somebody put a gun to your head and forced you to drink, right? Um, it's a hard one to prove, but assuming to prove that you did not get intoxicated, somebody forced you to, or that you did not know you were taking intoxicants, then you're not going to be held responsible for your actions. This could be similar to again the did not know you were taking intoxicants. If somebody hands you a drink, it's like, hey, is there liquor in here? Let's say it's a really good tropical drink, we can't taste the booze. No, it's a virgin. It's a virgin drink, and it turns out no, there's a butt ton of alcohol in there. Right at that point, did you know you were taking intoxicants? No. So should you be held responsible for like DUIs or anything resulting? Generally speaking, no. That being said, what about voluntary intoxication? Let's say you get drunk and you go on a shooting spree. Are you responsible? Yeah, you sure are. Right? If you voluntarily engage in this action, even if you didn't know what alcohol would do to you, does not matter. You voluntarily engaged in this action. You voluntarily took the risk that you could like lose your mind and go do stuff. So generally speaking, you are responsible for your actions. Similar to, and where things can get a little tricky, is what about if something is laced with something, right? So let's say that you buy a bunch of marijuana, and let's know it's laced with I don't know some kind of synthetic drug, like bath salts. Bath salts are the things that people take and then they go eat people's faces on TV, like they're really, really, really horrible. Well, then things get a little tricky, right? Because it's like, did you know that the bath salts were in there? No, but you also voluntarily did do the drugs, so it does get a little bit tricky. Um, Even then, you're probably still talking involuntary if you didn't know it was laced with something. But let's say that for the first time, you take bath salts, and for most people don't go nuts, right? When they take it the first time, over time, it starts to like erode the brain, and yeah, people do go crazy. But let's say that, I mean, some people the first time they take bath salts, they go absolutely like crazy. It's very rare, but it does happen. Let's say you're unfortunately that person who goes crazy when you take it, um, and you kill somebody, you do some real massive damage to somebody. Can you say that, well, I didn't know that it was going to do this to me. It's the first time I've ever done it. No, because again, you took the risk of doing it. Sorry, right? If you're taking marijuana, it's laced with something. Okay, but if you're doing like heroin, it's laced with bath salts. Like heroin's enough to make some people go crazy. Like that's a harder of a case. The final thing we'll talk about in terms of defenses is entrapment. So entrapment basically is this idea that the police made you do it, right? That you would not have committed the crime but for the police essentially forcing you to do it, or a government agent, right? Again, this is only when you would have not otherwise committed the crime. So the police put it into your mind. Um, this is different than like sting operations and things along those lines. Like that is vastly different. Whenever you see like sex workers, who are undercover cops, and they're people Johns are pulling up and soliciting them. That's not entrapment, right? Or you go buy drugs from a dealer, and it turns out the dealer's an undercover cop. That's not entrapment, right? Because the question is who put the idea into your head, right? You probably did. And the question is, not only did they put the idea in your head, but it's for somebody who would not have otherwise commit the crime, right? If you're soliciting prostitutes, you pull over, you're probably the type of person who is going to commit the crime regardless. So the person was a cop or not. If you're buying drugs, well, you're the person who's buying drugs, right? Nobody forced you to do it. You just took the risk that the person you're buying the drugs from is a cop, right? So the question really is did and kind of generate with you, or did it generate from the law enforcement? Now it's a vastly different situation, right? If you're at home and you've never done drugs in your life, and somebody knocks on your door and is like, "Hey, would you like to buy drugs?" And you're like, "No." And you're like, "No, you really should. You really should buy drugs. It's good for you. It's good for your health. Like it'll make you feel better. It'll give you this like, kind of a euphoric feeling." And you're just like, "No, go away." And they keep pushing, keep pushing, keep pushing. Well, at that, and then you finally just relent and say, "Fine, I'll buy the drugs," and then they arrest you. That's entrapment, right? That is absolutely entrapment. Because the idea is did it come from you? Did you, were you inclined to commit this crime? No. In fact, you told the person, I don't want to commit this crime. But they kept at it, kept at it, kept at it until you ultimately did it. I had a case once. It was this small town sheriff. Uh, he comes into this bar, and this bartender had previously gotten a citation for serving someone underage. Again, not great, but it is what it is. So the sheriff comes into the bar, and he has a really like pretty young girl on his arm, and of course he's in uniform. Oh, no, actually he wasn't in uniform. Never mind. He wasn't in uniform. He was in plain clothes, but he still had his badge on. And I think he had a gun on too. He comes into the bar with her. He sits down at the bar, and he orders a drink. Okay, and so the bartender's like, "Okay, great. Your drink." And the sheriff is much older. He's an old guy. And then the girl next to him is like, "Oh yeah, I'll have like a rum and coke or something like that." And he goes, "Okay, yeah, that's fine. Just let me see your ID." Because I mean, she looked young. I mean, she looked like college age, right? So he goes, "All right, let me see your ID." And the sheriff is right there. He goes, "Why?" Again, he has his badge on. Everybody knows him. It's a small town. He goes, "Why?" He goes, "Oh, it's just the law. Like I got to. Obviously, sir, you are well over 21. But she looks young, so I need to see the ID." And the sheriff goes, "You don't need to see it." And the bartender goes, to his credit, the bartender's like, "No, I have to, right? Like she, I have to make sure she's in that age range where I have to check." And the cop just keeps trying to like, "No, you don't have to. Don't. No, don't." And the bartender, I mean, to this person's credit, keeps pushing back. And at one point, the sheriff looks at the bartender and says, "If you ask for her ID again, I will arrest you." And so the bartender's like taking a step back, like, "Okay, Jesus." So the bartender goes and gets him a drink, gets her a drink, right? Gets her the rum and coke. He comes back. The sheriff arrests him for serving a minor. As it turns out, she was underage. Now, in this case, was this entrapment? Absolutely. Like, positively, absolutely entrapment. Why? Because this guy did everything he could not to commit this crime, but law enforcement essentially forced him to do it. And that's usually how severe it has to be to prove entrapment, right? It has to be something that intense. So that being said, how do we check for entrapment? Well, there's two ways. There's two ways. Most states use the subjective trap test for entrapment, whereas a minority of states use an objective test for entrapment. So most states use this subjective test, which basically asks is whether the intent to commit the crime originated from the defendant, right? Basically, is did this defendant did the intent originate from them? Or did law enforcement, put the intent into their heads or the idea into their heads? So if the intent generates from you, right, like you solicit somebody who tends to be like a sex worker, well, that's on you, right? Even if they're an undercover cop. They didn't, force it on you. You're the one who pulled over voluntarily, right? But if somehow they force it on you, right? They come to your office and they parade like prostitutes through your hallway. Well, that changes things up a little bit, right? Or sex workers through your hallway. That changes things up a bit. But again, if it's just regular on the street and you decide to pull over, then that's on you. So that being said, right, that is where our objective test is. So one of the cases on point that talks about this is Oliver versus State of Nevada. So what happens is in Oliver versus State of Nevada, Las Vegas police are conducting a decoy operation. Um, they're in like a main part of of the Strip in Las Vegas. Um, it's an area that's a little bit kind of, I guess it's not on the main strip itself, but it's kind of adjacent to it. It's often frequented by people that they describe as, quote, street people, which is, again, an unfortunate term, but that was the term they used in the case. So, an undercover officer is posing as an intoxicated homeless person in this area, and he's slumped against a palm tree with a $10 bill visibly poking out of his pocket. So, he's in an area where there's a bunch of homeless people. He's pretending to be passed out, homeless, and you can see money poking out of his pocket, right? So, there are two officers who are concealed nearby who are watching him, right? And what they see is they see Oliver, who is homeless. He's walking past. He notices the guy passed out by the tree. So he goes over and starts shaking him, trying to wake him up, and telling him that, police could arrest him because, he's homeless and he's passed out there for vagrancy. Um, and so what happens is he's shaking him. He's trying to get a response, and Oliver doesn't respond, or excuse me, the officer who's undercover does not respond. Now, Oliver starts to initially walk away, but then kind of notices out of the corner of his eye that $10 bill sticking out of the officer's pocket. So he turns around, right? He takes the money from his pocket and says, "Thanks, homeboy." And then at which point, as soon as he grabs the money, he's immediately arrested by officers, right? And the question here is, did the actions of the police constitute entrapment of Oliver, right, for grand larceny? And weirdly enough, the Supreme Court of Nevada said yes, that he was entrapped. And why was he entrapped? Well, because that law enforcement may provide opportunities for individuals to commit crimes, they cannot employ extraordinary temptation or inducements that would entice someone not otherwise predisposed to commit the crime. So in this case, this person was just trying to help. They took this extraordinary enticement, extraordinary inducement to force this person to commit a crime. Because $10 means everything if you're homeless. So did they set this guy up in the Las Vegas Strip where anybody just walking past can get him? And only criminals would go in his pocket? No. They put him in an area that is all homeless people. They put a little mice in his pocket in an area that's just full of homeless people. And for a homeless person, $10, right, could be the difference between eating and not eating for weeks, right? It's a big, big deal, right? And in this case, they put this guy in an area where vulnerable people are. Homeless people are vulnerable people. And they displayed the money. But when they looked at what Oliver did, Oliver initially went to go help him. He wasn't trying to take the money or anything like that. He was trying to help him, trying to get him awake, trying to do whatever he could. And it was only as he was walking past, after the person wasn't responsive, that then he turns around and takes the money. So the idea here is did the intent come from him? No, it didn't come from him. Right? The inducement was so massive and he was such a vulnerable person that at that point it does become entrapment. Right? Now, had the same scenario taken place on the Las Vegas Strip, right? Like not where the homeless people are, but literally on the Las Vegas Strip itself, where people, thousands of people walking past, all of them usually have a lot of money, and they see a homeless guy slumped over with a $10 bill. Is that an inducement? No, I mean, no, you're gambling, thousands of dollars at a time. It came out of Las Vegas Casino. $10 is nothing. So that probably wouldn't have been entrapment because the only people who would have stopped by to get it are people who are criminal. But if you go after a vulnerable population and somebody is there trying to help you, right? And then as they walk away, if they're trying to help you, the money just becomes too much because again, it's the difference between living and dying. Then at that point, yeah, that's entrapment. Now that's in most states. Minority of states, right? A minority of states use the objective entrapment test for entrapment. So this is the intent. So again, the person did not have the intent, the original intent to commit a crime. So the intent originated with the government, and their actions would tempt, quote, an ordinary law-abiding person to commit the crime. So again, here, instead of just who did the intent generate with? Was it your intent to engage? Here it's not only was it your intent to engage, but would an ordinary person, just a normal person, commit that crime based on whatever inducement there was? Um, Again, think about the Oliver case. Oliver, would this be entrapment under the minority, the objective test? No, right? No, because did the intent originate with the government? Yeah, probably. But would a $10 in a homeless man's pocket tempt the average, ordinary, law-abiding person to commit the crime? No. No, it wouldn't have. So the subjective test, ordinary or Oliver gets off, right? Because again, that was just ridiculous what they did. But the objective test is he probably wouldn't have gone off because the average person, again, who's not necessarily homeless or anything like that, would not be tempted by $10, right? The average person would not be tempted by $10. So it's part of the reason that this is the minority test. Most people are like, the government's actions are really bad, or are really inducive, or really pervasive, then they should be held responsible. Otherwise, it's not fair. So that being said, that concludes this lecture on defenses. Please remember, especially for exam purposes, you always start by analyzing the crime. You go through the elements of the crime. What if this is a rape case, right? What's the actus reus? Is it present? What's the mens rea? Is it required? If so, what is it? Is it present? Is there concurrence? Right? Does this require attendant circumstances? If so, what are they and are they met? Does this require causation? If so, what are the circumstances and what are is it met? If assuming that there's the criminal liability there, then you go down to the defenses, right? Was this justified? And you look at the different defenses and see what could apply, and then you analyze it by looking at the elements and requirements. And then if that's no, there's no justifications that apply, then you look at excuses, right? Are there any excuses apply? What are the elements? Are they met? Are they not met? How are they met? How are they not met? And then ultimately, if they're not met, the person is guilty. If they are met, the person is not guilty. That being said, we'll talk a little bit more about it as it approaches the final. And I appreciate you all for taking the time to listen to this lecture.